seeking your lordship indulgence, my lord. With respect to item number 9, I pray for this week, my lord. The next week I will do it.
Item 9, when do you want it, Mr. Raj Barbhuya?
My lord, I should not go through the details of the
When do
file.
you want it?
Next week, my lord. Or at your lordship convenience.
As prayed for by Mr. M.H. Raj Barbhuya, learned counsel appearing for the petitioner, which is not objected by the other side, relist on such and such date, given date after 1 week. Next, please. Yes, Mr. Goswami.
My lord, item number
10.
Item number 10.
10, yes.
The accused were convicted, my lord. But I was engaged by the company, not by the accused, my lord. And company has taken away the brief from me. But since nobody has appeared, I have seen in the cause list. It's a criminal matter, my lord. I may be allowed some time so that I will try to contact the person concerned.
It's a revision petition.
Yes, my lord.
And if you want, you can still represent if you want. If they don't, if they have already taken, they have taken away the brief from
My
you.
lord. Yes.
Heard Mr. S.S. Goswami, learned counsel appearing for the petitioner. Also heard anybody there?
My lord, I have taken consent of the other side over
Oh,
telephone.
PP, you're there. M.S.A. Begum. Huh?
Lordship, we are,
In item 10, I see your name.
Lordship, we are there, Lordship.
A. Begum, learned APP for the state respondent. Mr. Goswami submits that though the petitioner has taken away the brief from his office, however, has not made any alternative arrangements to for representation thereof. He fairly seeks a short accommodation to intimate to the petitioner as regards the listing of the matter. Relist on such and such date. Yes, Mr. Goswami, when should we list it?
My lord, after 2-3 weeks, my lord.
Give it after about 15-16 days.
10th December.
10th?
December.
You send a registered post letter,
Yes, my lord.
and then on the next date, if they don't appear, then you give it to us.
My lord.
And then if you agree, we may appoint you only as an amicus.
My lord. My lord, the 10th of December.
10th, is it okay?
Deeply.
All right. Any more mention, please?
Lordship.
Yes.
Item 4, Lordship.
What do you want in item 4?
For the day, Lordship.
For the day. Okay. As prayed for by Mr.
J.M. Sulaiman.
J.M. Sulaiman, learned counsel appearing for the writ petitioner, appellant, relist on such and such data that did deduct.
Discussion in the 12, Lordship. Item number 12, Lordship.
Same.
12. Engaged informed that counsel is not well, Lordship. 12.
12, the engaged counsel is not well.
Not well, Lordship. He informed me about phone telephone.
In item 12, hey, I got to Hurgun. The earlier one was 4, right?
Lordship? Yes.
Now 12, so and so submits that Mr. A.H.M.R. Chaudhary has informed over phone that he's not keeping well today, and accordingly a request on his behalf has been made. Prayer is not opposed. Relist on such and such date after 15 days later. Next, please.
Documents on item 8, my lord. This all matters, but some file is not.
Okay.
asked.
Item
So
8.
1 week accommodation may be given, my lord.
Mr. M.J. Barua,
Yes.
learned counsel appearing for the petitioner, seeks a short accommodation in the matter in order to go through the brief, as the matter has been listed after several years, right?
Old case, my lord. Listed previous also, but we have not constructed. Now we will do after 1 week, my lord. So
Since the matter pertains to since the matter being old, the brief has been misplaced, and accordingly reconstruction or kind of attended. Relist after such and such, after on a date deduct so and so. Yes.
24.
26 it may be.
Yes. Next.
Obliged.
To after December, December date. The reconstruct koribo. I think Mr. Barwa, you take a date in December,
My lord.
because you're reconstructing.
Yes, my lord. File we already reconstructed, but some
Okay, then it's all right. Yes, next, please.
For hearing item number 1 and 2.
PC Act. Yes, Mr. Chaudhary. Hussain, yes.
The last occasion I've already submitted. The person is dead. He's already dead. They have to verify. That's why we are waiting for a verification report.
Yes.
Lordship, the process is all is going on.
All right, as prayed for by MS
N. Chaudhary.
and Chaudhary, MS and Chaudhary.
Yes, your
Learned
lordship.
counsel appearing for the
CBI.
CBI relist on such and such data date.
This is for item number 2, my lord.
And in order to submit the verification report as called for earlier by this court by order dated 30/10/2025. Item 2 list along with.
Item 2, my lord, there is actually on last occasion, the court made an inquiry whether he is still there because he was around more than 90 years.
Then
Then we have verified he is still alive. my lord.
in item 2,
And the short paper will be allowed to take because in the judgment, my lord, all the evidence has not been taken care of.
Okay.
That will,
at your cost.
yeah, at my cost, my lord.
And item 2, you list both the matters together and a paper book be prepared at the cost of the parties.
A date may be fixed, my lord.
And list on such and such date. A matter to devote, 2 to devote, because there to
We
Yeah.
have already submitted the, that's it.
This is abandonment, my lord. Whether it is abandoned.
so in item 2, huh? And both together listing
Yes,
Yes.
and list along with Courier
and because
data.
of same case.
All right, next,
Wait. Second of December.
next.
Item 3.
Lordship can be taken after some time.
Then have it on next week, huh? Today there is some difficulty. As prayed for by MS SD Chaudhary, na? Sorry.
You, Nanda.
You Nanda, Learned Counsel appearing for the appellant relist on when do you want it?
Tuesday.
Tuesday, basically matter take Wednesday did you?
19.
Black.
Yeah.
Lordship, 5 and 7, can it be taken after something?
Hmm?
Item number 5 and
Okay.
7.
Next,
Item 6. Yeah, please.
yes, where is the respondents?
Not there, my lord.
Okay, next week,
Next week.
Mr. K. Bhattacharjee, Learned Counsel, so and so, none appears for the respondent number 2 on call. Relist, other date did you, next, after a week did you acknowledge?
26 November.
No, not 26, my lord. I'll be out of station.
That's all right, give a date convenient to Mr. Bhattacharjee. Yes, next,
Oblige, your lord.
Item 7.
Time-
7 has gone, I think he has just said it.
5 and 7, timing.
But there are only not much, so you ask who is coming. Yes,
Item 11.
give the file of 7 to Mr. Goswami, I think he wants it. I know. Yes, anyone there in 11?
Item 11.
It's a matter of defamation.
Hmm?
A matter of defamation.
Defamation, 11.
Nobody is there.
Dr. B. Ahmed and Hawk. Khandekar is there for the other side. May not have expected the earlier, the list to proceed so fast. Yes,
These types of cases, there is also perhaps no interest in the defamation case sometimes, my lord.
who has filed the petition?
The Swapan Kumar.
So the difficulty is these are criminal petitions. You can't just dismiss them also. I can
Yep.
wait, and if nobody comes, we can appoint a legal aid counsel and then take up.
Lord,
Let it be in the list called the next matter.
Lord,
Item 13.
What is this revision?
he can go.
PCRI, he said, huh? Let's see which is the order under challenge. the order of 10/11/2014
Yes, Lordship.
upholding conviction under 448 and 325. Simple imprisonment 1 month and 6 months. 448 325 IPC. So maximum given is 6 months. 6 months is probably for 325, na?
Yes, Your Lordship.
Where do I find the impugned order? Mr. Goswami, we'll do it this matter. You have it?
I have to figure LCR.
Did you PCR, did you?
Lordship, it may be hard some other.
No, then I will have nothing to do now. This is the second last matter. Let us try, let us see.
Yes.
Don't worry. I shall accommodate you. Don't worry.
Yes.
You take take it as an opportunity for you.
Yes.
Can you just point out in which page the judgment is? I think it is at page 25. Isn't it?
25 years, Lordship.
Right, page
Yes.
25.
Please, 25.
This is the appellate judgment. So the trial court judgment would be before this. Let's see the trial court judgment. Trial court judgment is at page 14. Now you read page 14, okay?
Yes, Lordship.
It starts from
Page
15.
15 years.
Yes. What is your name?
As Musahari, Lordship.
Mushari, yes. Yes, Ms. Mushari, you can start from prosecution case.
Informant Sandhya Chaudhary lodged an Ejehar before the Dibrugarh police station, stating inter alia that on 3/7/2009 at about 9 p.m., the accused pelted stones on her house. Thereafter came to her house and asked her to open the door, and when she opened the door, the accused beat her and her face, thereby causing injuries to her. It is further stated in the Ejehar that as she was undergoing treatment, there was delay in lodging the Ejehar, Lordship. In para 3, as per police and investigations, on receipt of the Ejehar, Dibrugarh PS registered a case and
Are they related? What? Mr. Goswami, do see that, huh? Now you come to page 16. I have carefully perused from there.
Yes, Your Lordship.
You are there?
If your lordship gives a little bit of accommodation, because I was out of station, I came last night.
This
only.
Mushari is doing good. Huh?
Lord, with your lordship's help, possibly.
Yes, we were trying.
Yes. My lord, I leave it up to her.
Let's see. If there is difficulty, of course,
Right.
we'll give it another date.
Fine.
Let her try.
Yes, better.
Yes.
Yes, Your Lordship. I have carefully perused the case record and also heard lengthy and elaborate argument advanced by learned additional PP and learned defense counsel Mr. U.K. Saha. To have the decision of the case, let me discuss the evidence on record.
Don't be nervous, Miss Mushari. Yes.
Para 8, coming at first to the evidence of the medical officer who was examined as PW5 by the prosecution. PW5 is Dr. Navajyoti Soikia. He deposed that on 4/7/2009, he had examined Sandhya Chaudhary on being escorted by H.G. Giril Dehiya with the alleged history of assault by her neighbor.
So they're neighbors.
Yes, Your Lordship. And on examination, he found the following injuries. Loss of 2 upper incisor teeth. And second is mild swelling over the cheek. And third is tenderness over jaws.
Loss of 2 upper incisor teeth, mild swelling over the cheek, and tenderness over jaw. So the slap was with quite force.
And it was Fist.
Must be have been a punch.
Punch, my lord.
Yes, please, Ms. Mashari.
The age of injury was
6 to
6
12
to
yeah.
12 hours and nature of injury was
Was
grievous.
grievous.
He identified his signature in Exhibit 3, the medical report as Exhibit 3-1. During his cross-examination, he stated that he had not mentioned the time of injury, but have stated that it was about 6 to 12 hours ago. He also deposed that he could not ascertain whether the fall of tooth was natural or not. And as per para 9, your lordship, from the evidence of this medical officer, it appears that Sandhya Chaudhary was examined by him on 4/7/2009, who was escorted by a home guard, and he had found loss of two tooth of the said victim. And he had also opined that the injury was 6 to 12 hours ago. And as per para 10, your lordship, coming next to the evidence of victim as well as informant to the case, that is Sandhya Chaudhary, who was examined as PW1, she deposed that on 3/7/2009 at about 7:30 p.m. accused came to her house and used unparliamentary words to her and gave a first blow to her on her
Fist
face.
blow.
Yes.
Yes, fist blow to her on her face.
Which caused in loss of 4 tooth and blood came oozing out. Thereafter, she informed the matter to her sister who resides at Rajgarh, and on their arrival, he went to Gabharu Pathar OP and lodged the Azhar against the accused persons, from where she was taken for treatment. He identified her signature in Exhibit 1 Azhar as Exhibit 1. Exhibit 1.
But this is fracture or dislocation of a bone or tooth. So seventh
We'll see
Uh,
the exhibits, my lord. Exhibit 1 is the medical report. We'll check what is there.
yes, just see the nature of
Nature of injury is grievous as per the.
But that is okay. But whether it falls under those 8 categories of section 320 or not, see
Yeah.
that.
That is why, my lord, 326 registered, 324 convicted.
3?
24 convicted.
It's not 325. I
Sorry,
think 325.
sorry, lordship, 325.
325 convicted, isn't it? Punishment for voluntarily causing grievous hurt.
Yeah,
So therefore, grievous hurt has to be there.
there, lord.
Now, in order for an offense to be grievous hurt, the categories are given under 320.
Yeah.
So you check from the
Yes.
medical report whether it falls under, firstly, whether it falls under those
Yes,
categories. है ना?
Yeah, I think it will fall.
You just check.
I'll confirm, madam.
We will in the meantime carry
I'll
on with the. Yes, Ms. Moshari.
Yes, your lordship. She further stated that the accused had also pelted stone on her house before causing hurt to her. And on arrival of the police has seized the said stones by Exhibit 2, the seizure list.
Rupak. Dekat mati na. Teka. No, ebar yale mata sir.
Son was also present in the house,
Dekat yale mata.
and she does not know what is written in Azhar Exhibit 1. Denied the defense that no such incident took place, and she had lost only 2 tooths after she had fallen down, and she denied the other suggestions of defense.
So now she says she lost 2 tooth,
Yes, your lordship.
which is corroborated by the medical.
Medical. And also from the FIR.
Okay.
Fist blow on her face.
Punishment 6 months, na?
Minimum.
Okay. Yes, Ms. Moshari.
And page 17, your lordship. From her evidence, it appears that the accused entered into her house, gave her fist blows, and caused loss of her tooth.
Mr. Goswami, find out if that sister has been examined.
Yes, ma'am.
Huh?
Yes.
It further.
One second, Ms. Moshari.
Yes.
Just one second. Yes.
Yes, your lordship. It further appears from her evidence that her elder son was present in the house at the time of occurrence.
Elder
Son,
son. He's PW2.
PW2.
Yes.
And she has informed her sister, and on her arrival only she had informed the police.
Okay. Yes.
When PW2 Abhijit Chaudhary, the son of the victim, in tune with PW1 Sandhya Chaudhary, deposed that at about 7:30/8 p.m., the accused came to their house and using unparliamentary words gave a fist blow to his mother, and thereafter blood came oozing out and she became unconscious. He then informed his aunt, who resides at Rajgarh, and on her arrival, his mother was taken to the police station and thereafter to medical for treatment. During his cross-examination, he deposed that he had not witnessed the incident as he was inside the house. And after coming out, he had seen his mother lying unconscious and blood was oozing out from her mouth. Para 12 Lordship, PW3 Dhira Mohan Roy and PW4 Uma Roy, who are the brother-in-law and sister of the victim Sandhya Chaudhary. Both of them deposed that on 3/7/2009, the son of the informant Abhijit Chaudhary informed them over telephone that accused had inflicted injuries to their sister Sandhya Chaudhary. They
So
immediately
four is the sister.
Yes, your lordship.
4 is sister.
Uma Roy.
Yes. Yes.
He then rushed to the house of the victim and after reaching took the victim to police station and she was thereafter sent to medical for treatment. During cross-examination, both the witnesses stated that they had not witnessed the occurrence and had heard that it was the accused who had given her fist blow, and both these witnesses have denied the
So
suggestion.
basically 2 eyewitness, 1 and 2. Victim and her son.
Victim might not, two is not the eyewitness because
Two
he
is, he says,
says that he is inside the house but did not saw the assault. When assault was made, he came and but he was in the house, so he informed to her.
he was
aunt
inside the house
inside
at
the
that
house.
time.
Because
After coming out, he had seen his mother
Mother.
lying unconscious and blood.
yes,
Okay. Only one is the victim. Yes. Yes, Ms. Mushahari.
During cross-examination, both the witnesses stated that
They had not witnessed the
they had
occurrence
not witnessed the occurrence, Your Lordship.
and
And
had
her-
heard.
It was the accused who had given her fist blow, and both these witnesses have denied the suggestions of defense. Now, as per Para 13, PW6 Hogeswar Bora, the investigating officer to the case, who deposed that on 12/7/2009, after receipt of Azahar from Sandhya Chaudhary, GD entry number 282 dated 12/7/2009 was entered and thereafter he was entrusted with the investigation. He then recorded statement of witnesses, collected medical report, seized stones, arrested accused, and after completion of investigation, submitted case diary. SI Rajan Soikia thereafter submitted charge sheet, that is Exhibit 4, Your Lordship.
Yes.
During cross-examination, he deposed that he went to the place of occurrence on 12/7/2009 and the incident had taken place on 3/7/2009.
Yes.
That he had not sent the victim for treatment.
All right. If we may just pause here for a moment.
Yes, Lord.
Now, this is basically the evidence, right, Ms. Mushahari?
Yes, Lord.
This is the evidence. There are overall total 6 prosecution witnesses and there is 1 eyewitness, correct? Now, what does the eyewitness say, Ms. Mushahari?
P-
That when she was inside the house, the accused had come and started using unparliamentary words and thereafter gave her a fist blow on her face for which she lost about 2 teeth. Correct? 2 teeth. That's right. And then her son came out and saw his mother lying unconscious. She also said she told her sister. Sister also said yes. Both the son and the sister has told her. So basically, evidence seems to be corroborating each other. And the medical is which one? Dhiren
Exhibit one, my lord.
Exhibit 1.
One.
He's
There
he's
i-
not PW.
He is, yes, he is MO, my lord, and
MO is not a witness or what?
he is a witness, man, because he
So where is he?
he is my
Which
lord,
number?
uh,
5.
five, man, five.
MO is 5.
MO is 5, 6 is IO.
Correct.
Right.
So 5. He has also said,
Yes,
Mr. Goswami,
yes,
now you are holding the trial court records.
yes, yes.
Can you please read PW1
One.
once? It's in vernacular.
And
We'll go to all that later on.
Lordship's inquiry regarding the
Yes, we will connect it later.
Lordship. আছামিক মই চিনি পাওঁ মোৰ ঘৰৰ ওচৰৰে 3709 তাৰিখে ৰাতি 7:30 বজাত মই ঘৰতে আছিলো ঘটনাৰ সময়ত আছামী বেয়া বেয়া গালি পাৰি মোৰ ঘৰত সোমাই আহে আৰু মুখত ঘুচা মাৰি চাৰিটা দাঁত পেলাই দিয়ে মোৰ মুখৰ তেজ ওলোৱা পাছত মই সাহ কৰি ৰাজগড়ত থকা ভনীজনীক ফোন কৰোঁ ৰাতি মোৰ ভনী আহে আৰু আউটপোষ্টত জনায় পুলিচক লগত মোক পুলিচৰ লগত চিকিৎসালয়লৈ যাওঁ চিকিৎসা কৰি মই ঘৰলৈ আহোঁ থানাত এখন লিখিত আজাহাৰ দিওঁ দিয়া আজাহাৰ মোৰ চহী এক্সিবিট 11 মোৰ চহী ঘটনাৰ মোক আছামীয়ে আমাৰ ঘৰলৈ শিলগুটি দলিয়াইছিল পুলিচ তদন্ত কামত মোক ক'বলৈ আহোঁতে পুলিচক শিলগুটি দেখুৱাইছিলো আৰু পুলিচে শিলগুটি জব্দ কৰিছিল It's also painted stones, my lord.
That she
yes.
told in her FIR, but so here also she's saying,
He's saying that to give the face blow and his teeth dislocated, my lord.
and before that he had thrown stone.
Scolded and rebuked her with that language.
No, initially he pelted stone.
Initially painted stones.
Then
again,
he came in,
and
started using unparliamentary words,
and
then
also
fist blow.
face blow.
Yes. But what is the motive? Anything has come.
Motive, my lord.
He's a neighbor.
Amar, yes.
He has to be.
Let's
Yes,
see
yes.
anything given in the 313.
Yes, yes.
I just want to check.
No, but and also read the sun once. Let's complete it.
Yes, ma'am. I'm whether I should go to that cross part also or
Yes, please.
PW1 cross, ma'am.
Go slow. You have the whole time.
Yes, ma'am.
Well,
Yes.
if required, I may just author the, I might just dictate
Yes,
the main facts and all, and then if
Lot.
required, we'll give her time
Lot.
for tomorrow or
Lot,
her
lot.
senior.
Lot.
But otherwise,
We can.
I don't see that
Yes.
there is much case in Mushari, your case, because you see, it is ultimately a revision jurisdiction. Two concurrent findings are against you. Correct? And evidence is there. It's not a case of no evidence. The question whether a grievous hurt is attracted or not, that particular is going to be another aspect. We will look into it. We will look into it.
Okay.
But at this moment, you cannot say there is no criminal offense. Criminal offense is there. He had gone to the house of PW1.
Yeah,
He had
agree.
pelted stone. He had used unparliamentary words. And he had given her a fist blow on her face, for which she has lost 2 of her teeth. This is corroborated by her son, by her sister, and the medical officer. So evidence is very clear, Ms. Moshahari, isn't it? Now, when evidence is clear, if you want this court to set aside the order of the trial court as well as the appellate court, then you have to show me that there is some jurisdictional error or material illegality committed by these courts. I don't see. We will see the grounds. You may read out the grounds from your appeal after. Let me just complete this part and then we'll come to you. Let us complete the evidence. Yes. Just to satisfy everything, you finish that evidence part.
PW1.
I'm only indicating my mind to you so that you can quickly go through the grounds that you have also taken. Yes.
Yes, minor the cross part. মোৰ ল'ৰা দুটা, মই আৰু মোৰ ডাঙৰ ল'ৰা ঘৰতে আছিলো। আসামী বাহিৰত হাজিৰা কাম কৰে। ঘটনাৰ আসামী আৰু আমাৰ মাজত হিংসা ভাৱ আছে।
Who said this in the cross?
In the cross, man.
PW1.
Yes, man. হিংসা ভাৱ আছে। দেখা নাই, মই ক'ব নোৱাৰিম। মই regarding the exhibit matter and the FIR matter লিখি দিয়ে। FIR was written by on her instruction matter. সত্য নহয় যে মই ঘটনাৰ দিনা ঘটনাৰ কোনো এজাহাৰ দিয়া নাই। সত্য নহয় যে these are suggestion all denied মানে। সত্য নহয় যে এসপ্তাহ পাছত মই এখন মিছা এজাহাৰ দিছো। শিলগুটি দলিওৱাৰ সময়ত মই ঘৰৰ ভিতৰত আছিলো। মোৰ কোৱাৰ্টাৰ ওচৰত some names are there. One কলিতা ৰেলৱে এমপ্লয়ী কোৱাৰ্টাৰ আছে। শিলগুটি দলিওৱাৰ পৰা মোক মাৰপিট প্ৰায় আধা ঘণ্টা সময় লাগিছিল। ইয়াত সময়ত কোনো ওচৰৰ মানুহ অহা নাই। সত্য নহয় যে ঘটনাৰ দিনা আসামী কামৰ বাহিৰত আছিল আৰু মই কোৱা দিছে ডিনাইড। সত্য নহয় যে মোৰ 4টা দাঁত লৰা নাই। সত্য নহয় যে মই পৰি যোৱা নাই, দাঁত সৰিছে। মোৰ ভনী ৰাজগড়ত থাকে। মোৰ ভনী 12:30 মানত মোৰ ঘৰত আহিলে। সত্য নহয় যে মই মানুহ অনিষ্ট কৰিম বুলি মানুহক ভয় দেখুৱাই আৰু সেইকাৰণে ওচৰ চুবুৰীয়া মানুহে আসামীৰ ওচৰত মিছা গোচৰ দিছো। সত্য নহয় যে these are all suggestions she has denied. Otherwise, her evidence is unshaken. That is what come out in the cross.
Yes.
PW2, her son, my lord.
Yes.
Her son, he is also inside, but is not the eyewitness. আসামী চিনি পাওঁ আমাৰ ঘৰৰ ওচৰৰে। ঘটনাৰ দিনা 7:30-8টা মান বজাত মই ঘৰতে আছিলো। তেতিয়া আসামী আমাৰ ঘৰত আহি মোৰ মাক বেয়া কথা আৰু ঘুচা মাৰে। মোৰ মাৰ মুখৰ পৰা তেজ ওলায় আৰু মা বেহুচ হৈ যায়। তেতিয়া মই ৰাজগড়ত থকা মাহীৰ ঘৰত ফোন কৰো। মাহী আমাৰ ঘৰত আহে। This is also corroborated PW1 minor regarding coming of her sister-in-law. Aunt minor. আমি and then cross part মানে আমি দুইজন ভাই ককাই। মই ডাঙৰ। মই সৰুৰে পৰা মাৰ ঘৰত আছিলো। 2009 তাৰিখে 12 তাৰিখে মোৰ মনত নাই। 12 তাৰিখ হয়। 12 তাৰিখ হয়। সত্য নহয় যে 2009 তাৰিখ 12 তাৰিখে কোনো ঘটনা সত্য নহয় যে।
She's just denied it.
I denied it. This is a suggestion. All denied. ঘটনাৰ সময়ত মই ঘৰৰ ভিতৰত আছিলো। মই পাকঘৰৰ পৰা ওলাই আহি দেখো যে মা বাহিৰৰ ৰুমত সেন্সলেছ হৈ পৰি আছে। মই উঠাবলৈ আৰু মুখৰ পৰা তেজ ওলাই আছে। That is in the cross. PW2. And now my PW3.
That's all right.
Oh, sir. Go to the medical report.
Yes, please go to the medical officer.
I had examined Chandra Chaudhary, 42 years females, and it alleged history of assault by neighbor. On examination, I found following injuries: loss of 2 upper inside teeth missing, and mild swelling over cheek, tenderness over jaw. Age of injury 6 to 12 hours. Nature was grievous. Patient was given ultrasound, given exhibit 3 is the medical report, exhibit 3.1 is my signature. And this corroborates because he says that the incident is of night at 7:30 to 8, and
No,
and
this
she
is
was
okay. This
examining.
is anyway not a factual court.
Yes,
Go to the 313, anything in 313?
yes, and just yes, madam. Denied. Nothing, madam. All denial.
Hmm.
This is the evidence, madam.
Ms. Mashari. I don't think there is anything. I must tell you that you are arguing very nicely,
That's
but then you see the case. Now we are bound by the records, by the evidence, right? It looks like there's nothing. Who are you for? Oh, you are there.
The concurrent finding.
Yes, Mr. Dotto, it's a case of concurrent finding. That's what I have. So do you want to read the grounds? Or any grounds is there according to you? This ground number 2 is factual. 3 is also factual.
May I finish the other part, lawsuits inquired, my lord, regarding
Yes.
grievous hurt, my lord.
Yes.
It says, my lord, grievous hurt definition. Your lordship will find it in the 7th, my lord.
I've seen. I saw.
Yes,
I
yes.
told you that
That is-
7th
that is-
category.
Yes. sir.
It's there. What to do, Miss Mashahari?
not sure.
I can dictate the judgment, not sign it. Keep it till tomorrow, giving an opportunity to your senior Mr. Doctor in case he has something to say, but nothing on the factual aspect, because factual aspect you have already clarified. We can do that at best.
Yes, your lordship, that may be.
Or at
I
2.
At 2 is also.
Is okay.
Okay.
At 2. I will dictate it now. So once one of your colleague come, you can just ask him to just ask her to inform him also that at 2 I'm going to keep it. But I will call someone, please. You want to say something?
No, that's. Only one thing, my lord, regarding the eyewitness part, my lord. Here, my lord, he is the injured witness, my lord. So the injured witness, my lord, evidence should be is not at par with
See-
other witness. That is what.
Is not at par.
Not at par with.
No, but
says-
Mr. Goswami, this is a factual
Yeah,
aspect.
that is
This is the third court.
third court, my lord.
There has to be something glaringly.
Yes.
You see, the manifest error has to be there.
Yes. No.
I don't find any such perversity
Yes.
or illegality committed by
Yes.
the.
Yes, that is what I am saying. AW1 is on higher pedestal, my lord.
And the only purpose we have gone through the evidence is to see if there is some error.
Lordship.
Only for that limited purpose, not for reappreciating the evidence.
Any perversity is there.
Correct. Only for that part. So that we have seen. That apart, there is nothing. I also tried to see if a case of simple hurt is made.
Yes.
But no grievous hurt,
Grievous hurt.
apparently the category is there.
Yes.
And there is no question of reducing because this 6 months doesn't seems to be an excessive
Yes.
term.
Minimum.
I tried because if it can be reduced. But you see, he's a neighbor. He has no right to go and slap a woman, isn't it?
Yes.
And looks like maybe she does not have a husband
Had it been a my lord.
because no male members except her son they are mentioning.
Yes.
We don't know
Yes.
if she's a widow or she is
Yes.
separated. We don't know that. Anyway, so what business does this man have to go to her house, throw stone, then to give her a fist blow,
No.
filthy?
No.
It doesn't look good. And he's given 6 months. He's fortunate
Fortunate.
he got 6 months.
Otherwise, it is maximum 7 years.
Correct. 7 years maximum. At least 1 year too he should have got.
And to the extent of slap is okay, my lord. But
Correct. That's what I'm saying. Fist blow.
Fist
Two
blow.
of her tooth has fallen down.
Fallen down.
That's not right. It does not. So, Ms. Mushari, you have understood everything. So you communicate this to your senior because I don't think he can improve anything. What you did, you've done. You've done the best. Isn't it?
If unless that T25 has been set aside, that sentence cannot be reduced because.
That's
they are
right.
not-
That's right. That's right.
This is the-
That's right. That's right. That is why I'm on 325 only. I asked Mr. Goswami to check those 8 exceptions. It falls on under the 7th category.
And fine.
Anyway, in case something comes, because I will not conclude, I will keep that part for tomorrow. But let me make a. Otherwise, this whole judicial time goes for a waste. Okay. I'm going to put your name.
Okay.
Heard
Anything
MS.
comes, my lord, I may be given to be referred. If anything comes from my lord.
We'll see if required.
Lord.
Heard MS.
S. Musahari, Lord.
S. Mushahari, Learned Counsel, appearing for the petitioner. Also heard Mr. M.P. Goswami, Learned APP for the state respondent, and Mr. P.B. Datta,
EP.
P.P. Datta, Learned Counsel, appearing for the respondent number 2.
I have newly updated that.
Oh, the amended cross title is not there. For the newly included informant stroke respondent number 2. Huh? Yes, Mr. Datta.
Lord, exceeded 2 and go through.
I am giving the judgment, but I will not sign it till 2. 2, I will give you a little bit of opportunity because you see, I'm sure you know the fact a little bit. Ms. Mushari has done a good job, but she cannot improve what is there, right? Now here is a case where the accused petitioner, who is a neighbor of the injured, went to her house, pelted stone, and went inside and gave her a fist blow on her face, for which she lost about 2 teeth of hers. Her son, who's PW2, though was inside, didn't see, but corroborates to the surrounding attending facts. Similarly, her sister corroborates the surrounding facts that she called and all. The doctor corroborates the loss of the 2 teeth. 313, you don't take any defense, you don't take any plea, you simply deny. Now, the problem is this is a revisional court. I'm bound by the concurrent findings unless, of course, something glaringly correct. So that I don't find. 2 courts have held against you. Factual.
There is something.
Correct. That part you see, because factually they have taken, this is the 3rd court, not for on facts. Correct.
Yes.
So anyway, now that I'm good you are here, because you will see when I'm dictating. So I will complete that part of the dictation and I will keep a concluding paragraph. And I also saw, I was trying to see if I can reduce the sentence that it is 6 months that has been given. Maximum 325 is 7 years. And under the 7 category, loss of tooth is there, grievous hurt. So 325 also is made out. And I don't think, Mr. Doctor, that the 6 months is an excessive or a disproportionate sentence, considering,
The nature of injury.
correct, he's her neighbor. He has no business to go to her house and give her fist blows, isn't it? And she stays alone with her son. Of course, we don't know about the husband anything because nothing is there on record. But nonetheless, this much is there. Only her son was there. And we don't see the husband mentioned anywhere. So we don't know. And she only she immediately called her sister. So probably we don't know, maybe separated, maybe widow. We don't know about all that. But whatever be it, you see, the accused petitioner had nothing, no business to go to a lady's house and give her fist blows. And that is, if you ask me, maybe 6 months is less. So only to that, I don't think there is much. But if, of course, if you have to point out something glaringly, erroneous, I shall manifest error or something, I shall accordingly change that part at 2 o'clock. Okay, now you take your seat. The present revision petition is directed against the judgment and order dated 10/11/2014 passed by the Court of Additional Session Judge FTC Dibrugarh in criminal appeal number 7/1 of 2014, affirming the conviction of the petitioner under section 448 and 325 of IPC so and so, whereby the petitioner has been convicted under section 448 and 325 of IPC so and so, and sentenced to undergo simple imprisonment for 1 month, and simple imprisonment for 6 months with a fine of rupees 500, and in default to undergo simple imprisonment for 10 days respectively. Mr. Datta, just find out if this 6 month and 1 month is concurrently, or just check that. You can tell me later on. You just check, you can keep a note. It will run, sentence will run concurrently.
So far the judgment is concerned.
Oh, anyway, Mr. Datta, you do have a look.
The judgment.
The prosecution case in brief is that is that that on 3/7/2009 at about 9 p.m.
Concurrently.
concurrent,
At page 19.
sentence to run concurrently, Lekiriba. Thank you. At about 9 p.m., the accused petitioner pelted stones on the house of the informant stroke PW1 stroke respondent number 2, na? Respondent 2, right? 2. And went to her house and asked her to open the door. And when she opened the door, he gave her fist blow for which don't give her Facebook. He beat her on her face for which she suffered injuries. Huh? Stop. Accordingly, a case was registered under section. Initially, case was registered under what? Same section? 326. Huh?
Conviction under 325.
These are not there in the
In the
trial court,
first-
huh?
in the- I seen in the trial court judgment, my lord, in the first.
Where it is there?
Page 19, your lordship will see.
Page 19,
In para 22,
326 of.
325,
para 22.
starting.
It's 325, it says, no?
No, but perhaps in the appeal, my lord. In the appellate judgment.
Why don't you have returned the trial court record? Details and details. Just tell me what is the FIR sections?
Yes.
Because I'll break, otherwise the flow gets Itu to me, paragraph 2 side over.
Yes, my.
Yes, I have
Here-
it. I have it. I have it. I have it. I have it.
Here case number.
The brief case of the prosecution into paragraph 2 over. Okay. Then after that, accordingly, a case has been registered under section 336/448/325 of IPC. And after completion of investigation, charge sheet was submitted under the aforesaid section. Thereafter, the petitioner pleading not guilty, the charges was framed under the trial court framed charges under section 448/325 of IPC and accordingly commenced the trial. During trial, the prosecution examined 6 witnesses, being the informant as PW1, the son of the informant, PW2, brother-in-law of the informant, PW3, sister of the informant, PW4, doctor who had examined the informant as PW5, and the investigating officer as PW6. The statement of the accused petitioner was also recorded under section 313 of CRPC, however, wherein he merely denied the incriminating circumstances that were put to him. All the incriminating were put to him. Huh?
Put 328 as well.
PW1 deposed that deposed that on 3/7/2009, the accused used filthy words against her and entered into her house, wherein he gave her a fist blow on her face, resulting falling of 4 teeth, and accordingly she suffered grievous injuries. The medical officer, PW5, corroborated to the who examined her, corroborated her injuries corroborate nokoma. They deposed that he found the following injuries. 1, 2, 3. Egeta paba page 60 not. He further deposed that the age of injury was about 6 to 12 hours and nature of injury was grievous. Stop. The son of the victim, who was inside the house at the time of occurrence, also corroborated the surrounding facts as deposed by PW1. Likewise, the other relatives, the brother and the sister, who were subsequently been informed about the occurrence, has also corroborated the other attending circumstances. Both the trial court and the appellate court, upon appreciation of the evidence of the injured informant PW1, the medical officer PW5, and other witnesses PW2, 3, 4, have found the prosecution version to be established beyond reasonable doubt. The appellate court, while affirming the conviction, has observed that there was an occurrence on 3/7/2009 at the house of the informant, and immediately after the occurrence, sorry. Has observed that the trial court has rightly passed the judgment in order of conviction, warranting no interference thereof, warranting no interference thereof. And hence, and the ocular and medical evidence sufficiently corroborate. It is further upon being satisfied that the ocular and medical evidence sufficiently corroborating each other, comma, uphold the conviction under section 325, and it was which was the other one? 448 325 of IPC. Stop. Learned counsel for the petitioner submits that the evidence on record in its proper perspective has not been appreciated by both the trial by the trial court and the appellate court, and hence there is abuse of process apparent on the face of records, and the judgments and the convictions having been arrived at are unsustainable in view of the same, and hence the petitioner is entitled for acquittal. He further, I'll keep Ms. Mushari's name. She further submits that there is perceptible contradiction in the evidence adduced by the informant, who deposed as PW1 against her own statement recorded under Section 161 of CRPC, as well as in the FIR. The informant in her evidence deposed that the accused petitioner used filthy words against her before entering into her house at about 7:30 p.m., whereas there was no whisper of using filthy words by the accused petitioner in the FIR, as well as in the statement of the informant recorded under Section 161 of CRPC. Rather, the statement recorded under Section 161 of the CRPC presents a completely different story, and the incident took place at about 9 p.m. and the accused person entered into the house of the informant without even making any noise, not to speak of using any filthy word. She further submits that the trial court as well as the appellate court failed to appreciate the fact that the informant in her deposition as well as in the FIR stated failed to appreciate the fact that the informant's initial deposition before the police officer as well as her statement in the FIR is in variance with her deposition in the court. She further submits that the informant in her cross-examination admitted that they were having enmity with the petitioner for a long time prior to the incident. She further submits that there being no eyewitness of the incident and she further submits that the conviction having been based solely on the basis of the injured witness is not sufficient to bring home the offense against the accused petitioner beyond reasonable doubt. Correct? Anything else?
There is one thing,
Yes, tell me.
in her evidence, the informant said that she was alone. But later, the PW in her cross-examination, she again admitted.
I will record it for your satisfaction, but see, Mr. Datta, these are all factual.
Factual.
Had I been in appellate court, of course, I would have reappreciated it. And sometimes there can be minor contradictions. Discrepancies can be there, 7 p.m., 9 p.m. Isn't it? But if you want, I will record it. Because all these grounds are factual.
Yes.
Isn't it?
Yes.
Yes, Mr. Goswami. Per contra, Mr. MP Goswami, learned APP for the state respondent supports the impugned judgments and submits that the injured witness's testimony is cogent and trustworthy, duly supported by medical evidence, and that both the courts having concurrently recorded have concurrently recorded well-reasoned findings based on evidence. Stop. Likewise, Mr. PB, na? PP, Punjab. PP Datta, learned counsel appearing for the informant stroke respondent number 2, whilst by supporting the impugned judgment, submits that the petitioner has failed to point out any don't say fail, submits that that both the trial court as well as the appellate court has not committed any manifest error and or illegality warranting any interference from the instant revisional court. I have given my prudent considerations to the arguments advanced by both the parties and have by the parties and have perused the materials available on record. It appears from the testimony of the injured PW1 that while she was in her house, the accused petitioner, after pelting stone, came inside the house and called her and asked her to open the door. And after she opened the door, gave her a fist and then started started abusing her with filthy language, and also gave her fist blow on her face, for which she lost almost 2 teeth, about 2 teeth. It appears that the medical officer fully corroborates the injuries alleged to have been inflicted by the accused petitioner. It further appears that the medical officer has also deposed that the nature of injury is grievous. It further appears that her son, who was inside the house, her son PW2, who was inside the house at the time of the occurrence, upon coming out, has seen his mother unconscious. It also appears that her sister, who she had immediately informed about the occurrence, has also deposed that she was informed that it is the accused who had bitten her sister, the informant. The testimony of the injured informant appears to be in 164, the same thing, na?
154, I'm not
See,
checking.
see 164.
Your Lordship, there is another fact that can be ruled out, that the informant, she was a patient of high BP. So the doctor, he suggested that this may be that she has fallen and due to that the injury.
Factual.
Otherwise all
Factual. You see, that medical report is there, na? Swelling and everything.
Yes. Yes. And another thing, the
That's
stones
factual, no.
which were found after 10 days.
Not relevant. Not relevant. Factual these are. That's why I'm indicating. Had it been in appellate court, maybe, reappreciated. But both courts have looked into the facts, applied their minds, and by reasoned order, convicted, correct. There I don't find any jurisdictional error.
Yes, that is of course.
It's not there. The testimony of the injured informant is found natural and corroborated by medical witness. Hence, the same is stop, huh? That apart, her testimony is also that apart, the other witnesses, though not eyewitness to the assault, have corroborated the immediate aftermath and presence of both parties at the place of occurrence, lending assurance to the prosecution case. Pertinent that the accused petitioner has not offered any explanation in his 313 examination, during his 313 examination after closure of the prosecution evidence, when all the incriminating circumstances were put to him. It is well settled that the revisional jurisdiction under section 397 and 401 of CRPC is limited. This court cannot reappreciate evidence as a third court of fact unless there is manifest illegality, perversity, or miscarriage of justice. Full stop. I will stop here. I am not dictating further. That I am leaving at 2 o'clock.
Or your lordship may dictate.
Okay. Upon perusal of the record, no such infirmity or illegality is found in the concurrent findings of conviction recorded by the trial court as well as the appellate court. As regards the sentence, the petitioner has been sentenced to undergo 6 months simple imprisonment for the offense under section 325 IPC, which prescribes a maximum punishment of 7 years.
7 years.
Considering the nature of injury and considering the nature of the injury and the manner in which the same has been inflicted by the accused petitioner, and the circumstances of the occurrence, the sentence imposed cannot be said to be excessive or disproportionate. For the foregoing reasons, this court finds no illegality, impropriety or perversity in the impugned judgments warranting interference in revisional jurisdiction. The criminal revision petition accordingly stands dismissed. The conviction and sentence of the petitioner under section 448 and section 325 IPC as recorded by the trial court as well and affirmed by the and confirmed by the appellate court are hereby affirmed. The petitioner shall surrender to serve the remaining sentence, if any, ordered accordingly, return TCR. Sorry, Mr. Datta, that case. Lastত পাতি দিবা আৰু আছে নে কেতিয়াবা পাতি লওক
Around 15, I'm for the respondent, I'm ready, my lord. Counsel for the Peter, he's also will join shortly, my lord, for time being, my lord.
Hmm?
He's
He'll come.
coming, He's coming. my lord,
Okay.
For time being. my lord.
Okay.
Pending item number 5.
Item number 5 and 7 in both these cases, I am representing. But I was out of station last night I have come.
You want some time?
Yes, madam, maybe.
I've given you the time. Your junior was saying keep it for some time. Anyway, when do you want it?
After 2 weeks, madam, both the cases.
You are Sharma, na?
Sharma, yeah.
In 5 and 7. Mr. K. Sharma, learned counsel, appearing for the appellant, with profused apologies, requests posting the matter on another date as he could not prepare for the hearing today since he was out of station and has only reached today morning. Prayer is not opposed, relist on such and such date. Give it after. Yes.
December 1st. Yes.
Yes, next.
I'm speaking after 4th.
Please sort it out there. Next.
Pending item number 11.
Lord, in this matter, we also some time, my lord.
You call for him. That's why you call for him. I've seen you from 10:30 reading your brief. So you call for the other side if you want your matter to be taken up.
My lord, 2 weeks time, my lord, granted, my lord.
Item 11.
Here,
Huh?
Item 11.
11.
11.
Yes, my lord.
Okay. As prayed for by Mr.
K. Uddin, my lord.
K. Uddin, learned counsel, appearing for the petitioner, relist on such and such date. Did you get that date? Yes. Yes, I can see. Matok 15 to Matok. Yes, Mr. Chaudhary.
I'm sorry,
Mr. Deka is, he looks like he summoned you here. He's been ready with his matter since 10:30. Huh?
One of this criminal revision against conviction matter.
Conviction.
Yes. 4 petitioners are before your lordship, my lord. They have been convicted by the magistrate, my lord, for offense under section 323,
Offense is under
323,
323,
where punishment is, my lord, RI for 3 months.
3 months.
Then, my lord, 320.
Alright.
RI for 3 months.
Yes.
Then, my lord, under section 324, RI for 6 months.
Yes.
Then, my lord, under section 326 IPC, RI for 18 months. That is 1.5 years.
18.
18 months.
18 months would be 1 year.
6 months.
6 months. Yes. Yes.
Fine of rupees 10,000. Out of which, my lord, 9,000 has to be paid to the victims, my lord.
Hmm. Yes.
Here, my lord, then appeal has been preferred, my lord.
Concurrent findings.
Concurrent finding. Here, my lord, only thing is that, my lord, whether under section 326 has been legally proved or not, my lord.
A dangerous weapon, na?
Yes. Grievous act.
Grievous, I've understood.
Yes.
But 325 is
By
grievous.
some-
326 is the dangerous
Weapon.
weapons. What was the dangerous weapon here?
They have, now they have.
Huh? Now.
Now. And there is. inside-
Thou seized,
Now not seized.
not seized.
Inside zones are there, my lord. But only thing, my lord, whether it will come under the definition of, my lord, 320 IPC, where, my lord, grievous, how it has been defined, my lord.
That is the
That is
the
want to, my lord.
jurisdictional
Yes.
challenge that you're making, the error. Huh?
Because, my lord, in the doctor, my lord, the doctor who has given, my lord, his opinion, nowhere in his report, my lord, he has mentioned that it is a grievous act. Though he has mentioned the injuries, my lord.
No, what are the injuries?
I am coming to that, my lord. Here, my lord, these are the, my lord, differences between, my lord, the brothers. Their
Two
mothers,
brothers.
they are all brothers.
Okay,
my lord.
before you go there, you just give me a little bit of brief facts because Mr. Chaudhary, I'm going to dictate it right away.
My lord,
So I'll need the facts.
yes.
This
Because
way or that way, whatever, we'll do it right away only.
informant and, my lord, the informant party and, my lord, the accused, they are brothers, my lord, but their mothers are different. Their father,
Stepbrothers.
yes, their
So
father, my lord,
accused and the informant is here. Is you are for the
he is the
informant.
informant, my lord.
So informant and the accused are stepbrothers.
Stepbrothers. He married, my lord, their father married 3 wives, my lord. Out of that, my lord, one, these accused persons are from one mother and they are from, my lord, another wife.
Anyway, where is the FIR? It must be there in the trial court judgment.
Yes, yes.
Where do we get the trial court judgment?
At page 26, Lordship.
Yes, let's see from there.
Yes.
Prosecution case in brief.
My lord, my beginning, my lord, this matter was heard by Honorable Justice N. Unikrishnan.
That's all right. It's
On
not
that-
part heard.
It is not part of.
Then
On that day, my lord, one question.
whatever happened on that day is on that day.
Yes,
Today is a new day.
yes.
So let us start.
Only thing, my lord, there are 4 petitioners,
Yes.
out of which, my lord, the petitioner number 4, my lord. He did not, my lord, claim juvenility before the trial court or the appellate court. But in the High Court, my lord, we have raised that point, my lord.
So inquiry is done by whom? By the board.
Only thing, my lord, we have given a document, my lord. And, my lord, as per the, my lord, Juvenile Justice Act, my lord. the
That is
matriculation
one of
certificate is
the
one of
94.
my lord, yes,
94.
Yes, my lord. On which, my lord, by relying
See,
on. that, my
I'll
lord,
keep this part heard.
Yes.
You look into it. I don't want anything. You just check this part. Yes, you are right. You rightly pointed out 94. 94 says if this is not available, then this.
Yes.
One of them is the matriculation.
First one is this, my lord. Matriculation certificate
Matriculation.
is the first one.
Correct. Just have a look at these decisions.
Hmm.
Huh? Monday?
Monday ki tarikh ho gaya?
Tuesday.
Can it be on Tuesday?
All right.
Hearing day?
All right. Heard Mr. B.M. Chaudhary, Learned Senior Counsel, Assistant.
No senior counsel.
You are anyway. Mr. So and so also heard Mr. P.K. Dekal, Learned Counsel, appearing for the respondent number 2 and B. Sharma. A plea of juvenile has been raised by the Learned Counsel by Mr. Chaudhary for petitioner number 4, enclosed as Annexure I to the appeal memo.
Annexure 1. my lord.
Annexure 1 to the appeal memo. Stop.
Revision petition, my lord.
In the revision petition. Stop. So this is by on affidavit, no?
Yes.
Accompanied by way of an affidavit. Upon perusal of the decision of the Apex Court in Vijay Singh versus State of Delhi, reported in 2012 8 SSC 763, it appears that the plea of it appears that the law is settled that the plea of juvenile can be raised at any time, even before, even after, at any time. Hmm.
My lord, can it
I
be?
think I think we can put it for hearing on Monday because para 8 is there.
Let it be on Monday, my lord, because Tuesday, my lord, I have got.
No, what I'm saying is this issue, even here, if I see, In fact, as stated earlier, this SLP was entertained on 39/11 since it was for the first time argued before this court that the appellant was a juvenile on the date of occurrence as per the date of birth recorded in the school leaving certificate.
Yes.
When we consider the said submission in the light of JJ as repealed by the JJ so-and-so as well as the subsequent amendment of so, it has now become incumbent upon this court to consider the said contention raised on behalf of the appellant in order to find out the correctness. Then everything has been mentioned, the act and all, and ultimately it says there's no point of remitting it. So I think we can do this.
Can it be on Monday, my
We'll
lord?
fix it for hearing now.
On Monday,
Or you want to do it today?
let it be on Monday, my lord. I will go through the
Okay.
evidence also, my lord.
Okay. But then let me at least take care of this part, this
Yes, yes.
objection.
Yes, my lord. Juvenility, my lord, no problem.
So I'll take this part then.
Yes.
Then এটিখানি কাটি দিয়া কি বিলি লিখিলা না তার আগতে কি লিখিলা মিস্টার চৌধুরী নয় না তার আগতে কি লিখিলা for the first time সেইটো কাটি দিয়াচোন এইখিনি কাটি দিয়া Mr. Chaudhary, so and so, by relying on the high school living certificate examination 2000 examination certificate admit card enclosed as annexure 1 to the petition, submits that at the time of occurrence at the time of occurrence the petitioner number 4 was about 15 years. Stop. It appears that for the upon hearing Mr. Chaudhary and going through and upon perusing the materials available on record, it appears that for the first time the plea of juvenile has been argued before this court on the basis of the date of birth mentioned in the HSLC admit card. The apex court in Vijay Singh versus State of Delhi reported in 2012, 8 SAC 763 held as under. A Torpra. '27. It appears that in the present petition, it appears that the petitioner number 4 by now has attained the age of about 31 years. Considering the age of the petitioner, it appears that there is no point of remitting the matter to the Juvenile Justice Court,
JJB Board.
JJB
Justice Board.
Juvenile Justice Board, for disposal, na?
Yes.
The board will.
For deciding, my lord, whether he is a juvenile or not.
No, that is to not required, but suppose suppose the board decides,
Yeah.
then it will go to where? To the JJ court?
Yes, JJB court only.
Correct. So that is what I am trying to say,
Mm.
not the board. Let us assume you are. To the Juvenile Justice Court where?
That is, my lord, Nagaon, my lord.
Nagaon, for disposal in accordance with law. Have you understood, Mr. Chaudhary?
Yes.
It's not about the determination of age,
Yes.
because this court is accepting the age.
Yeah.
But suppose your age is actually at that time 15. What is the point now?
No point sending, my lord.
No, Zain. And it is rightly that 94 recognizes. So that apart, since since under section rule 94, right?
যদি আছে তোমাৰ যদি আছে নেকি? পিছবেলা হ'ব বুলি ভাবি আছো।
Rules খন নাই নেকি ইয়াত? JJB rules খন লাগে।
ৰুলটো ওলা
এইখন যাক দিয়কচোন চৌধুৰীক দিয়কচোন উলিয়াই দিব।
আছে তাত এক না রুলস আচ্ছা রুলস সেকশন তো আছে
Mr. Dekka, you have no problem to this point? You're the informant because we are going with, otherwise we'll send it for inquiry for the age. Because you see all this decision says.
Yes, but so first this decision is concerned, my lord.
Correct.
Then the decision relied on that point, my lord. I have not confirmed, my lord, that this. all
So
those
what do you want?
And since instead of, my lord, of the finality given today, my lord, can it be on
But
Monday?
all
Yes,
right,
my
all
lord.
right, all right. এতিয়া এইখিনিতে কৈ দিয়ে that in view of it would give that in support কি বুলি লিখিছে that the decision of the apex সেইখিনি নকবা it further upon perusing the said HSLC certificate it appears that by now the petitioner number 4 would attain the age of 31 in Vijay Singh so and so this the apex court after considering the fact that the appellant therein had crossed the age of 30 years instead of remitting the matter to the Juvenile Justice Court upon the plea of juvenility being raised for the first time before the apex court. Was pleased to proceed with the hearing of the appeal and upon finding the conviction and upon finding that the conviction has been correctly made instead of directed upheld the same, however, quash the sentence imposed upon the appellant. Mr. Dekka so and so seeks for a short accommodation in order to address in this regard relist on such and such date. Fair enough. You find out. So you also see, but I think because I don't think this matter needs to go to the board for that decision. But one thing, even he is right. If we accept the certificate, then even if we find that the conviction has been correctly done, we will release you. The court will have to release you because the court can't uphold the sentence part, isn't it? Then the appellant might get, the informant might get prejudiced. So perhaps
Yes,
whether that inquiry is required or not required, only in that point, you also look in. Huh?
It will be section 94.
not rule 90.
Section. That was Rule 54. No, that was earlier,
It was
54? Section 54 it
Rule
was.
12 was
12 was there.
Correct. Rule 12. I was confused. Okay.
Nuclear blast.
Monday, my lord, Monday next.
Monday?
Monday,
Monday. कितना तारीख होगा?
Further.
Monday will be
17th.
18th.
Okay.
17.
Huh?
17, Monday.
No, 17th. 17th. Our pleasure.
All right.
Pending item number 14.
Further hearing কৰিব নালাগে.
May I plead your lordship? Lordship, kindly pass over the matter only for today, lordship.
আৰু কিবা? This is the last matter.
So,
You will argue?
the senior counsel is on another court for hearing, lordship.
What is this revision petition? You have the file? Why? Why you don't have the file? Right, spirit for release Tuesday. God, man, after a week did your consent. Yes.
19.